Hello and welcome. My name is Julie Westbrock, Vice President Development with TrustPoint. Thank you so much for joining me today as I discuss the 3 estate planning documents that you can't live or die without. Specifically, these documents relate to your healthcare, which is called the Healthcare Directive, your finances, this document is called the Power of Attorney, and your estate. Today, I'm going to talk about both a will and a trust. First up is the Healthcare Directive. In Minnesota, we call it a Healthcare Directive. In other states, it may also be referred to as a Healthcare Proxy or Healthcare Power of Attorney. Whatever it's called, the purpose of the document is to appoint a healthcare agent. This is somebody that's going to make your healthcare decisions for you in the event that you are unable. Typically, this is a trusted friend or family member. It's not going to be a company such as TrustPoint. We don't know you as well as your friends and family are going to know you. Within the Healthcare Directive, you can add instructions about your healthcare, what you want to see happen if you can't make your own decisions. You can include language such as whether you want life-sustaining procedures, whether you want to be an organ donor, and you can also include if you want to be buried, cremated, or if you have any specific ideas about what you'd like to see happen at your funeral. The next document is a power of attorney. This document allows you, the principal, to designate somebody, which is referred to as the attorney-in-fact, to handle your financial matters. Again, this is usually a trusted friend or family member. It could be a company such as TrustPoint under certain circumstances. The power of attorney could be effective immediately, or it could be effective upon incapacity. This is called a springing power of attorney. The power of attorney document never takes away the principal's power to manage their own affairs. It could be created with limited powers, or it could be created for a limited period of time. One important point to note is that all powers of attorney end upon death. Therefore, if you are acting as attorney-in-fact for somebody and they've passed away, you no longer have authority over those assets. When somebody does pass away, the next document that's going to come into play is a will or a trust. The first one I'm going to discuss is the will. This is where you can add instructions about what should happen after you pass. You can designate who receives your assets and when you might want them to receive them. You can say who's responsible for the administration. This person is called the personal representative. Very, very important. Within the will is where you can name who you would want to take care of your children or dependents in the event that you're gone. This is where you really want to include the information because you don't want somebody who doesn't know you or your children to ultimately make the decision of who's going to care for them after you're gone. The will does go through probate. Probate is a legal court process whereby it's determined whether the will is valid, all outstanding debts and expenses are paid, and the decedent's property is then distributed after the pass. Now, an alternative to a will is a trust. A trust is a legal agreement that has 3 parties. The grantor, settlor, that's the person that makes the trust. The trustee, this is the person that manages the property. And the beneficiary, that's the person that receives the benefits of the trust property. A lot of people create what's called a revocable trust or a living trust. This is a type of trust that's completely revocable, meaning you can get rid of it at any time. Within the trust document, again, you can say who receives the assets and when you might want them to receive them. You can also state who you want to be responsible for the administration. This is called the successor trustee. The successor trustee can also step in the event that you are incapacitated. Now, one point to note is that trust assets can avoid probate if they are titled correctly. I always like to look at a trust as a bucket. It's the trust document that creates that bucket. And then you want to put your assets inside the bucket. For example, a real estate. I own a home, and in order to put my home into my trust, I had to change the title from Julie Westbrock as an individual to Julie Westbrock as trustee of the Julie Westbrock Revocable Trust. Provided your assets are titled correctly, they can avoid probate. Thank you so much for joining me today as I went through a very brief discussion of the 3 estate planning documents you can't live or die without.